Hello viewers, this is Animesh D. Hadley Philip, signing with my channel Learn to Ease, where learning is a pleasure. So today's topic is Introduction of Indian Evidence Act. Before moving on, I request my viewers to please subscribe my channel Learn to Ease so that you will keep getting on my new videos. Today we will discuss the introduction of the Indian Evidence Act. We will try to understand the topic in the point wise. So now the first point is, what is the name of the Act? Section 1 briefly defines the name of the Act as Indian Evidence Act, 1872. Now the second point is, what is Indian Evidence Act, 1872? If we will read the preamble of Indian Evidence Act, we will get to know that it is a consolidated act. Meaning is that Indian Evidence Act collects or unifies the evidence. It is a defining act. It means that this act defines the evidence part where it is necessary. It is an amending act. Meaning it amends the relating laws where it is necessary in that part. By the above discussion we can say that Indian Evidence Act is Consolidated Act, Defining Act and Amending Act. Or in another sense it is to consolidate, define and amend the law of evidence. Third point is Indian Evidence Act is a procedural law. Law may be broadly categorized under two heads, namely, 1. Substantive law and 2. Procedural law or adjectival law. The substantive law, whether statute law or common law, defines what facts go to constitute a right or liability. Example: the Indian Penal Code, 1860, the Indian Contract Act, 1872, Law of Torts, etc. Adjective law or procedural law, on the other hand, is one by which substantive law is applied to particular cases. It is also known as the law of procedure. It is concerned with the enforcement of right, duties and liabilities determined in accordance with the rules of substantive law. Example: the Code of Civil Procedure, 1908. The Code of Criminal Procedure, 1973. The present topic, Indian Evidence Act, 1872. Fifth point is, who drafted this act? And your answer will be Sir James Stephen. Sixth point, Indian Evidence Act is Act No. 1 of 1872, which means that in the year that is 1872 this was the first act passed by the Council. Be enacted by Governor-General in Council. Enacted 15th of March 1872. And it commenced or came into force on 1st of September 1872. Seventh point is where this act is applicable. It extends to whole of India except the state of Jammu and Kashmir. It applies to all judicial proceedings in or before any court. Section 2 Subclause 2 CRPC clarifies that applies to court-martials other than court-martials convened under the Army Act, the Naval Discipline Act, the Air Force Act. Eighth point is where this act is inapplicable. Affidavits presented to any courts or officers. Proceedings before an arbitrator. Ninth point is Indian Evidence Act is not exhaustive. The act does not claim to be exhaustive. Court may look at the relevant English common law for interpretation as long as it is not inconsistent with the fact. The act consolidates, defines and amends the laws of evidence. Evidence provisions are also in other acts, that's why it is said that Indian Evidence Act is not exhaustive. Best example is Section 16 Subclause 3 of the Indian Contract Act. 10th point, the Act has a retrospective effect. Means that the amended provisions enforcement can be done from the back date also. Section 113A of the Indian Evidence Act has retrospective effect. 11th point is law of evidence is lex fori. Phrase lex fori means law of the place of the action. Let's take an example. If two persons make a contract in Australia. If any one of the person brings a suit against other person in India to enforce that contract, then the Evidence Act of the said country is applicable, that is Indian Evidence Act. Explaining the law of evidence. By House of Lords in early 1850s. In Bain v. White Raven and Furnace Junction Railway, 1850. The law of evidence is lex fori, which governs the courts. Whether a witness is competent or not. Whether a certain evidence proves a fact or not. That it is to be determined by the law of country where the question arises, where the remedy is sought to be enforced and where the court sits to enforce it. Last point. Let's take one citation for better understanding this term. Shrees Chandranandi v. Arnandi, 1941. Privy Council. Privy Council held. If any witness is excluded by Indian Evidence Act, no matter how much fair that witness is, that witness evidence will not be admissible in any manner. Hopefully this video is helpful to you. Do subscribe my channel Learn to Ease, to boost me up, so that I can make many other videos that will be useful for you.